Okay, good morning. You're appearing.
Good morning, Judge. Ralph Elizondo, Assistant Prosecutor.
Danielle Bennett, Assistant Prosecutor.
Thank you.
And yes, good morning, Your Honor. May it please the Court, Delphia Burton appearing on behalf of and with Mr. Pugh.
Thank you, and good morning, Mr. Pugh.
Good morning.
Okay, on this morning, I had several sidebars with the attorney. Disclosed to all of the parties that in my prior employment, I did work with Mr. Pugh. Also disclosed to the parties this morning during the sidebar that I also know and have a relationship with the victim's family in this matter. And so I disclosed that information. I explained to the parties that it would not impede my ability to be fair and impartial and unbiased. And so I disclosed it, and I believe Ms. Burton is going to make a motion. I'll allow the people to make their record. However, I've already disclosed to the parties that while I know that I'm able to be fair and that I'm able to listen to the facts and make a decision based on the facts, that I do not want to give the appearance that there is any bias or any impropriety. And so I have already made the decision that I am going to recuse myself with respect to this matter. I've reached out, and the matter has been blind drawn already. The case will go to Judge Deborah Langston, but I will allow the parties to make the record. Ms. Burke, is your motion. You may proceed.
Yes, Your Honor, as it relates to MCR 2.003, that relates to the disqualification of a judge. This Court has already stated on the record that it's not just actual prejudice or bias that must be shown, but the appearance, and pursuant to People v. Perkins, that's located at 193 Mishap 209, that's a 1992 case, the very appearance, I think, would impede due process, and the fundamental fairness of a case is what's most important.
Okay, thank you. In response, Mr. Elizondo.
I don't hear counsel arguing that this Court would be biased, and I don't hear counsel arguing that the Court would be prejudiced. So, you know, the analysis as to those two things, I think, are off to the side. The analysis, I think, really comes on whether there is an appearance of impropriety, whether there would be an appearance of impropriety if this Court were to continue on as a trial judge. There have been case law that has dealt with these issues, in particular, in Ray MKA 286 Mishap 546 and 567, 2009 case. It quoted Michigan v. Keene at 451 Mish at 498, and it indicated there that the inquiry here is an objective one, whether under a realistic appraisal of the psychological tendencies and human weakness that the judge's interest poses such a risk of actual bias or prejudice, that you must be disqualified. In People v. Ivory, 2012 case, Judge, it's a Michigan Court of Appeals case 6554770. The Court describes some situations where the appearance of where the risk of actual bias is too high, and it would require a judge to recuse himself. They listed 1 as a pecuniary interest in the outcome, 2 has been the target of personal abuse or criticism from the party before him, 3 is enmeshed in other members involving and other matters involving the petitioner, or 4 might have prejudged the case because of prior participation as an accuser, investigator, fact finder, or initial decision maker. Due process requires a removal of judge only in extreme situations. Your Honor, I put to you that none of those circumstances fit in this map. This Court has indicated to us that you could be fair and impartial. We indicated to the Court that we, even knowing the relationship and how you described it with Mr. Pugh and with the witnesses involved in this case, that we felt confident that this Court could do a proper job in deciding this case, and we believe that the requirements for recusal weren't and are not met in this case.
Thank you. And I did allow the parties to make the record. And you're right, Mr. Elizondo, I do not have a pecuniary interest in this matter. I have no other matters involving the petitioner. And while you may not believe that this is an extreme matter, just because of the nature of the relationship that I have with the family of the victim, I don't want to give the appearance. And you're right, this is, as you know, I am going to make my decision based on the fact, as I indicated to the party when we were in the sidebar, I plan to leave this job whenever I leave with a T number, and more importantly, with the integrity that the people of this beautiful city have entrusted and believe that I have. And so it will not impede my ability to carry out my duties. However, I am not going to give the appearance that there is an issue or that I'm not capable of or that I may give favor to one party or the other for any reason under the sun, which would also impede the process of having this matter go forward expeditiously, which everybody has a right, especially the defendant, to a speedy trial. So with that said, I am going to recuse myself. Your motion is granted, and the matter will be assigned to Judge Deborah Lewis Langston, and the parties can go over to her courtroom. I believe that it is courtroom 203. The probable cause conference will be conducted on this morning. She has already been notified that she should be awaiting you. Thank you.
Thank you, Your Honor.
All right.
Okay. Thank you, Judge.
Stafford?
Oh, people accidentally take it. That's fine. One time I was at trial, he had left his notes on the podium, and I got my notes on top, and then taken them, and we had like a quick talk, we didn't know where they were. It was really funny.
No, she was getting ready to. Judges on the bench, remain quiet.
Is he looking for me?